thank you for that very, very kind introduction. I won't introduce myself any further, but I am very grateful for the introduction because it's really important that you understand my background in order that I am able to help you through the presentation that I'm about to give. And the presentation, it's more of an interactive session, only slightly interactive, because I know that students don't like to be too interactive, don't like to answer too many questions, be put on the spot too much, but I hope the balance is just about right. So the session that we are dealing with is expert advocacy. Anything I can do, you can do better. And I hope the reason that I've chosen that topic makes sense as we bump along together. Okay, so thank you for your patience with that, everybody. The purpose for this slide is exactly what it says at the top, which is for you to understand that we are in this together. And the reason that we are in this together is because I've been exactly where you are. Now, as we go through this session today, and we're going to have a look, as I've said, at some aspects of advocacy, which I hope you will enjoy and I'm certain you will learn from. Do feel free to join in. If you have any questions, just ask me. I'm very, very happy to be asked questions, and I hope that you enjoy the fun. And I promise there is some fun somewhere. Next slide, Gary, please. Okay, so an introduction really to the bar course in a very, very general way. Next slide, please, Gary. And just to tell you something that you probably already know, and that is what the overall aims of the bar course are. The aims of the bar course are to bridge the gap between academic study and vocational study, because the two are very different, to prepare you for pupillage and chambering opportunities, to prepare you for life at the bar, and to prepare you for interview and selection procedures. Because as I often say to students, it's all very well if you are the smartest student in the world, but actually if you're not able to demonstrate that in an interview or selection procedure, then nobody will ever know just how brilliant you actually are. And what we're going to look at today is in advocacy is something that will enhance your capabilities right across all of those areas. So next slide, please, Gary. And what are those areas? Well, the areas on the bar course you probably know already are separated into skills and knowledge areas. The skills areas are advocacy, conferencing skills, drafting, opinion writing and legal research. And the knowledge areas are criminal litigation and evidence, civil litigation and evidence, and professional ethics. Now, out of all of those subjects, there is one about which you will worry most. Could we have the next slide, please, Gary? And the subject that you will worry about most is advocacy. Now, I would like to be able to see the chat here because I would like to ask this question. How many students are concerned about their first advocacy session? How many students have already decided they might be a little bit nervous about their first advocacy session? Anyone? Okay, so in 0.1 second, there was an answer that said me. And Mohammed, thank you for that. You are very brave answering that question. And I can tell you that almost everybody in this session will have the same worries. And if you haven't, you probably should, but that's okay. And I'm going to tell you why, and I'm going to tell you what we're going to do about that. Okay, so next slide, please, Gary. So why will you panic about advocacy? Well, there's lots of reasons. Should I give you some of the reasons why I panicked about advocacy? And you might not believe them now that you see me on the screen talking, apparently very confident and very comfortable in any group, any environment. Well, you might be panicking about advocacy because you think, well, I'm a little bit shy. Or actually, I'm a bit on the quiet side. I don't have much experience of public speaking. Actually, not only do I not have any experience of public speaking, I'm absolutely, totally terrified. I might make a fool of myself. I think everybody else will be better than me. All of those are reasons why students tend to be very, very nervous about their first advocacy session on the Bar Course. Now, if any of those things apply to you, or in fact, if all of those things apply to you, let me tell you that that is okay. That is perfectly, perfectly normal. It is a big leap into your first advocacy session, but remember, everybody is in the same position. And remember that all of your advocacy tutors have been there themselves. When I was a student, when I was your age and I was on the Bar Course, we used to be in classes where not everybody had a turn at advocacy every week. So if I was very, very smart and very, very quiet, I could actually get through a session without having to say a thing. And I was always delighted when that happened initially, but then I was always devastated because actually when the next advocacy session came around, I still hadn't practiced the skills that I needed to practice. So if that feels like you, if you're that nervous, remember, I was in exactly the same boat. But it is our job as advocacy tutors to encourage your confidence as well as your skills. And for me, the biggest part of what we do when you first join the Bar Course is to encourage your confidence. You are in a totally safe environment, and do you know what? You will make mistakes, as will everybody in your group, and we will all learn from them. And at the end of the programme, you will be absolutely staggered by how much you have managed to achieve. So could we have the next slide, please, Kerry? So we're going to do some myth busting together around this. Next slide, please, Kerry. So students often say, I don't have any experience. Don't worry. That's not necessary. If you have some, that's great. If you don't worry about it. Some students say, I'm not very confident. And I've seen other students who are really confident. I bet they're really good at advocacy. Well, I can tell you from 1,000 years of experience of teaching advocacy that confidence from the outset doesn't necessarily equal ability. And quite often, it is the students who are significantly overconfident at the outset who actually don't perform so well. Because with all of that confidence, they sometimes struggle to learn anything from their tutors because, don't you know, they know it already. So if you don't have any confidence and you don't have a clue at the moment, don't worry about that. What will happen is that as you build your confidence, your skills will gradually develop beside them. I can't give you confidence, but what I can do is to teach you how to be confident in your appearance and in your delivery. And one day, that confidence that you are pretending to have will manifest itself in actual confidence. And to use one of the more modern slogans, well, modern for a person of my age, I'll teach you to fake it until you make it. And one day you'll be in advocacy class, like every student who comes before you, and you think, do you know, actually, that was just fine. So trust the experts, trust me, trust the other tutors, do your preparation, make sure that you attend your sessions, and we will turn you into an advocate, an expert advocate at that. Next slide, please, Gary. And how do we do that? Well, recognising that this is a subject that you will be very nervous about, you will be taught in a group with only 4 students. Okay, so as I said before, you are in a very safe environment. You will find that the students that you are in an advocacy class become some of your best friends on the programme. Generally, an advocacy group of 4 work together. They tend to have a WhatsApp group between them. They are incredibly supportive of one another. They are incredibly forgiving of one another's mistakes, and they work very hard to ensure that every member of the group is able to perform to their best. And in that little group of 4, you will have me or another advocacy tutor providing you with one-to-one focused feedback to help you develop both your confidence and your skills. Next slide, Carrie, please. And this is one of the courtrooms in which you will be taught. And there is something about being in a courtroom of this kind that just helps you to fake it until you make it. There is something about standing up in a courtroom that looks like this that helps you to believe better in yourself. And that in turn increases your confidence, which in turn allows you to build your skills. Next slide, please, Carrie. Thank you. So, expert advocacy. For me, there is no advocacy that is not expert. Real advocacy is a skill, a real skill. And once you have developed it, you will apply it in all sorts of areas of your life. As I said earlier, right at the very beginning, it will be relevant not only when you are finally on your feet as a barrister, but also in your applications for chambering, in your interviews that you might be required to undertake. Once you become an expert advocate, as you will be at the end of the bar course, you are able to express yourself in any situation in a much more impressive manner. Next slide, please, Gary. Thank you. So advocacy is a specialist skill. There is no doubt about that. It is the skill that distinguishes members of the bar from legal practitioners in any other context. You may well be aware that solicitors in England and Wales are not the expert advocates that members of the bar are. And it is, as I've said, the distinguishing feature. You will know yourself the reputation of those barristers who have studied and trained and qualified for the bar in England and Wales. And it's expected that on every single occasion, without exception, you will present your case to the very best of your ability. So as we move through, and just the next slide, Gary, please. Remember, just to the next slide. Sorry, Gary, has the slide changed? It hasn't for me. It should say...
Remember?
Yes.
Remember slide, yeah. It's a remember.
Yes, that isn't what I can see, okay. But as long as you can see it, that is the main thing. So it should say, remember, I can do it, so you can do it. And my job as an advocacy bar course tutor is to show you how to do it. And one day, like many students who've come before you, you will be a better advocate than me. So next slide, Gary, which should say types of advocacy.
Yep, yes.
Yes, you have that. Okay, so and to the next slide, because there are different types of advocacy. I'm completely without a screen now, so I can't see what you can see. So this is called winging it, which is fine. So the types of advocacy are oral or written, mostly. As I've said, it's the most significant element of a barrister's training and practice, and it is what we describe quite frequently as the art of persuasion. Have a screen back. Next slide, please. So when we talk about written advocacy, what is it we talk about? Okay, what is it that we are dealing with? Well, you probably know this already. But what we are dealing with are things like documents like particulars of claim, defences, skeleton arguments, or applications to adduce evidence. There used to be very little written advocacy in criminal proceedings. Usually written advocacy was the remit of civil barristers with particulars of claim and defences. But there is an increasing amount of written advocacy in criminal proceedings following the introduction of the criminal procedure rules and various rules about the admission of evidence, where, for example, you might be required to submit a skeleton argument about the admissibility of bad character evidence or hearsay evidence, or you might be required to submit a defence statement, which is actually fairly complex and therefore properly considered to be a piece of advocacy. Considering then oral advocacy, in the next slide, please, Gary. There are two types of oral advocacy that you will deal with on the bar course, all right? The first is submissions advocacy, which is predominantly civil, and the second is witness handling advocacy, which is predominantly criminal. Just to the next slide, please, Gary. What is submissions advocacy? Well, submissions advocacy is where you submit an application of one kind or another to the court. It might be an application for an injunction. It might be a submission on the admissibility or inadmissibility of evidence. It might be a submission on the applicable sentencing guidelines or on the relevance of a particular case. It might be a plea and mitigation in a criminal case, but it is a submission that you make directly to the judge. It is, Your Honour, my submission is that this bad character evidence ought to be submitted because. All right? And your opponent may oppose your submission or may not oppose your submission, and the judge will ultimately determine whether they are with you or not. Okay? So it is more of a one-to-one submission between you and the judge. Just to the next slide, please, Gary. And then we have witness handling advocacy. Okay, for most students, this is what they get excited about most. This is the business that you have seen on television. The examination in chief and cross-examination, sometimes re-examination, but that's quite rare, the examination of a live witness. Okay, so that is usually, as I've said, the part of the programme that the students look forward to most. That is the bit of the work that makes you feel like a real life barrister, but it's also the part usually that students are worried about most. And I don't know whether that is the same for you all. Do you look forward to the opportunity to examine real life witnesses, to ask them questions, to challenge them, to put that deadly point in cross-examination, which shatters their account? Anybody look forward to that? Or is it all just nerves at this point? What do we think? Nerves or excitement? Maybe they're two sides of the same coin. Okay, both of them motivated by adrenaline. So next slide, please, Gary. So is this business of expert advocacy a natural performance skill? Next slide, please, Gary. Well, it's certainly a performance skill. There is no doubt about that. You are performing. Anybody who is attracted to the theatre is almost always attracted also to the bar, because there is a performance involved. You are required to persuasively and concisely address the court in relation to the matters at hand. You are required to persuasively and concisely put your case to a witness and ask relevant, pertinent and efficient questions of individual witnesses. But, and just to the next slide, please, Gary. Is it a natural talent? Is it something that you're born with or not? Well, the answer to that is no. Some students think you either have it or you don't, and I don't. So what am I going to do? Well, can I tell you that that is nonsense? The idea that you have it or you don't is nonsense, okay, as you can see from the slide. No way, not at all, absolutely not. It is a performance skill that you can learn. And it's a performance skill that whatever your nervous situation at the moment, you will learn. I promise you, you will learn. Just to the next slide, please, Kerry. So how do we learn it? How do we go from zero to hero in terms of expert advocacy? Well, you work hard, you organize yourself, you prepare incredibly well, and your performance will be based on your level of preparation. So you're required to read very carefully your case. You are required to analyze that case very, very clearly. And then it's preparation, preparation, preparation. Next slide, please, Gary. So you may have heard this expression. I think it comes from the armed forces, but I adopt it frequently, which is proper preparation prevents poor performance. And that is absolutely true for advocacy. It was once said by a very, very excellent barrister that excellent advocacy is 90% preparation and 10% performance. And it is. And I can't tell you how much that is true. And I'd like you to be heartened by that, okay? Because what that means is that if you do your proper preparation for each of your advocacy classes, okay, at first you will find that everything is fine. All right? As the course goes on, you will find that actually everything is really good. By the end of the course, if you keep those levels of preparation up, you will find that in fact you are probably quite excellent. Okay, so please know that the key to being a good advocate, okay, and being an expert advocate is pretty much in your hands. And it's not about the skills that you stand with at the moment. It's about whether or not when you join the bar course, you put in the graft, you put in the work, you do the preparation. Okay, and it's 90% preparation before you get there. And the last 10%, the icing on the cake, is the delivery of what you have prepared so far. Okay, next slide, please. So how do we do it? And on to the next slide, please. There are two key principles of excellent advocacy. And I think this sometimes comes as a surprise to students because I think there is sometimes a misconception that good advocates must use incredibly long sentences and they must be very verbose and they must be very fancy and they must be very flowery in their language. Well, I can tell you that all of that is nonsense, okay? It is plain English that is required. And the two key principles of good advocacy are clarity and brevity. That is, be clear and be brief. And just one more tip on the next slide for good luck. Be well structured. Okay, make sure that your submission or your examination is well structured. Otherwise, you will be on a road to nowhere. You won't understand where you're going, nor will your tribunal. Everybody will lose interest. And even if you've got the best point in the world, it doesn't really count because everybody stopped listening. Okay, but to the next slide. So we're going to have a go. Now, I am going to rely on you a little bit. Okay, I promise it's super, super easy because what I want to demonstrate to you, if I can, is how few rules there actually are for you to learn to become an expert advocate. Okay, so, but I do need your help because if you don't help me, Miss MT and Gary are going to have to answer these questions in your stead, okay? And then you'll be in trouble. So, just on to the next slide. Remember, two principles, clarity and brevity. Be clear and be brief. And on to the next slide, you've got 2 questions. I would like you to tell me which of those 2 questions is the better question. Have a read. Okay, we've got, I just have to look at another screen and I can get the chat, so this is great. Whoa, we've got lots of B's there. Okay, why is B the better question? Why do we think B is the better question? Exactly, Julian. It's concise. Okay. Short, straight to the point. Excellent. Direct, understandable for everybody. Excellent. Excellent points. Okay. They are precisely the kind of points that I would make to you as an advocacy tutor. It's short. It goes straight to the point. It is concise. It is direct. It is understandable for all. Okay. And that is exactly right. So we don't need to mess about with that convoluted option A. We get straight to the point and we ask the very, very simple question. Dr. Lim, please could you tell the court where you were at 8 p.m. on the 21st of September? Excellent. Next slide, please, Gary. Question A, folks, or question B? Some answers coming in already. Yeah, well done, everybody. Okay. Now, just look at question A. Mr. Alston, are you able to clarify in detail, if you may, the precise circumstances which culminated in your presence at the scene of this event, Sutherland Hall? If I ask that question, what might the witness say? What might the witness say, do you think? Politely. Then they're very likely to say, exactly, Rahad, exactly. Pardon? Could you repeat that, please? Okay. And as an advocate, there's nothing worse than a witness saying, excuse me, what was your question? And the reason for that is you've probably completely forgotten, because as soon as you ask one question, you're busy thinking about the next question, and the last question has disappeared from your head entirely. So the very, very simple question that we ask is, Mr. Alston, why were you at Sutherland Hall? Now, that is, on a scale of 1 to 10, how complex do you think that lesson is? Do you already understand how we formulate those questions, being concise and being brief? Does that make sense? Yes or no? I think the answer is a yes. Yes, yes, yes. So can I tell you this? You have just learned the very first thing that you would learn when you come to the bar course at Northumbria or indeed anywhere else. Okay, so you are officially now ahead of the game. Congratulations. Okay, because as I said a little bit earlier, one of the things that I would like to explain today and help you to understand is that whilst the skill of advocacy actually seems a monumentally complex task, it isn't actually. It's about following some very, very, very simple rules, and that's one of them. Question construction. Be clear and be brief. Okay, so let's just have a look at examination in chief and cross-examination. The next slide, and then the next, please, Gary. Thank you. To make the point that I've just highlighted already, there are very few rules to remember, but you just need lots of practice. Okay, and on to the next slide. So I'm just going to go through some rules and some guidance with you, just as a gentle introduction. So none of this is new when you come to the bar course. Examination in chief is the examination of your own witness. So a witness who you are calling to further your case, okay? So you are inviting them to tell their story. There is one rule. The rule that you must follow is that you must ask non-leading questions, okay? So you must ask non-leading questions. The remainder of the points that you can see on that slide are hints and tips, okay? If you don't follow points 2 to 6, you won't be breaking the rules, okay? Your examination won't be as effective, all right? But you're not breaking the rules. The rule is non-leading questions, unless it is in relation to a matter that is not in dispute, okay? So if both of the parties agree, then you can ask a leading question, all right? So non-leading questions, don't lead the witness, allow the witness to tell their story, ask one question at a time, piggyback, and I'll get to what that means in a moment, chronological order, and think of the answer, then formulate the question. So think about what you want that witness to say, and then you ask a question. So just on to the next slide, please. Yeah, I think this needs a few clicks. You can just load it all, Gary, if that's easier. So no leading questions, except on matters that are not in dispute, okay? So what are matters that are not in dispute? Usually the parties agree that the incident took place on a particular date, for example. Okay, there might be disagreement about what happened on the date, who hit who, whether Mr. A burgled the house or not. Okay, but it's agreed that the house was burgled on the 22nd of December. The only question is whether or not it was the defendant. Okay, so where matters are agreed, you can ask leading questions, but otherwise there are no leading questions. So that takes us to the next slide and the question of what is a leading question. A leading question, and you may know this already, is a question which assumes or suggests the answer or some evidence that has not already been given. Okay, so a leading question suggests the answer or gives some evidence that the court hasn't already heard. And we're going to look at some examples of that in a moment. But just to help you, the next slide, excuse me, I've got a terrible cold. Non-leading questions often begin with who, what, where, when, why, or please describe. Okay? Because you are drawing information from the witness. Who were you with that day? What were you doing there? Where precisely were you? When did you arrive? Why were you there? Please, can you describe what you saw? Okay, all of those are drawing information from your witness who you would like to tell their story. Next slide, please, Gary. And piggybacking. Okay, does anybody know what we mean by piggybacking? Well, you should, from the picture that you can see on your screen. Piggybacking is a child's game that seems to have gone drastically out of fashion since I was very young. But it is the business of jumping on the back of somebody else while the person runs around and you all have a fabulously fun time. The point of it in the context of expert advocacy is that you ask one question on the back of another question, okay? So I might ask, if you imagine, I ask the questions, the witness gives the answers. Where were you on the 7th of September? I was at home. Okay, my next question builds on that answer. Please, can you tell me where your home is? Answer, it is in Newcastle. Thank you. Could you be more precise and give me your home address? Yes, my home address is X, Y, or Z. Okay, so one question is built onto the back of the next question. On to the next slide. So cross-examination. Do we all know what cross-examination is? You probably do. You've probably seen it on TV. You've probably seen some horrifically bad examples of cross-examination on TV. So your first lesson in cross-examination from me is to forget everything that you've ever seen on the television, okay? Most of it is nonsense. Lots of it occurs in the US, where they take an incredibly different approach to the approach that we take in England and Wales. And it seems to me often forget their manners. In the US, there's lots of wagging of fingers and banging of tables and stomping around the courtroom. You will find that in England and Wales, we don't do any of that, okay? We are, even though cross-examination challenges your witness and can be quite confrontational, you will, and I know that you will not struggle with this, you maintain excellent manners and a professional approach at all times. What is the point of cross-examination? Well, we can see that from the next slide, please, Gary. You do ask leading questions. You do challenge the witness. You do undermine the witness. You are there to discredit them. Sometimes you get a little bit of help from them, but you must put your case. And you can see highlighted there the one rule of cross-examination: put your case. Okay? So remember I said there are very few rules. It is the same for cross-examination. The rule is you must put your case. The other matters you can see there, the first three, will help you to conduct a good cross-examination. But if you don't follow them, you won't break the rules. It just won't be great. All right? So please, again, be assured that there are not millions of rules to follow. There are few rules, but you just need lots of practice. So, how about some practice right here, right now? And when you start on the bar course, you can know that you have got some of this in the bag. So if we could just go to the next slide, Gary, we're going to have a little go at examination in chief, okay? It's not too testing, and you can do it by popping an answer into the chat, but it's just to illustrate those fundamental principles that we've talked about. Now, remember, what is the rule of examination in chief? Before we go any further, what is the rule? What kind of questions must you ask? Just pop it into the chat. What kind of questions? Exactly. Well done, everybody. Okay, so we've got Wesner and Corinna and Joshua and John and Julian. Lots of answers, all correct. Non-leading questions. That's the rule. So let's move to the next slide. Please, Gary, thank you. You would like to establish that the witness that you are examining in chief observed a woman. Which question do you ask? Question A or question B? Lots of right answers very, very quickly there. I'm going to request that everybody who's in this session, who is joining Northumbria, are in my advocacy sessions, because you are doing very well already. Yes, why is the answer B? What is the problem with question A? Why is question A no good? Okay, so it suggests, doesn't it? Question A suggests, exactly. So question B, I'm just looking at, I just have to look at the other screen to see the chat come in. Exactly. Question A is suggesting, isn't it? It is suggesting to the witness that the person that they saw was a woman. It is a leading question. You are including the answer that you want in the question that you are asked, and you are leading the witness towards an answer that says it was a woman. That is a leading question, and it's not allowed. Question B is the question that you ask. Was the person you saw a man or a woman? Now, is that, do you think, a complex question or a simple question? Was the person you saw a man or a woman? Is that a simple question for you to construct? Exactly. Well done. It's simple, isn't it? And it is a perfect question. Absolutely perfect question. Okay, so here you are, months from joining a bar course, okay, and you have identified already not only what the correct question is, but the simplicity of that question. Okay, on to the next slide, if we could, please. So you'd like to establish that the woman the witness observed was wearing a dress. What do you ask? Exactly. Yeah, my chat is just like rolling. Exactly. What was the woman wearing? Okay. Question B is leading, isn't it? Because it is suggesting that she was wearing a dress. Okay, you are planting the idea that the witness was that the person was wearing a dress. Okay, you are leading the witness towards the idea that she was wearing a dress. So you just ask simply, what was the woman wearing? That's it. That is your second question in this examination in chief. Okay, and if you were to ask question A, that is absolutely the perfect question. And on to the next slide. So you'd like to establish that the dress the woman was wearing was red. Okay, so we now have evidence that she was wearing a dress. We know it's a woman. We know she was wearing the dress, and you want to know if it was, you want to know that it was red. Okay, you know it's red, but you can't say that. We need the witness to say that. Which is the right question? B. Yeah, quite right. Why is A the wrong answer? What is the problem with answer A? Exactly. Well done. It's an assumption, isn't it? You are presuming, you are assuming, you are suggesting. Okay, this is you telling the witness, isn't it? In one way or another, what you want them to say. So you don't. You stand back, you ask the non-leading question, what colour was that dress? And hopefully the witness will say red. Now, that's it. That is how you examine a witness in chief, by asking non-leading questions. Is that simpler or more difficult than you expected when you imagined your first advocacy class? Simpler. Yay! It's simpler, and because of the fact that you have attended this session today, you are ahead of the game. And I hope two things. I hope you are happy about that, and I hope you enjoyed that exercise a little bit. Because the key, as I've said, is understanding really that there aren't many rules to learn. You just have to practice. Because obviously, as the bar course progresses, the scenarios will become a little bit more complex. Sometimes it can be a bit tricky to formulate those non-leading questions, okay? But you have the basics in terms of non-leading questions absolutely in the bag. So well done. So you might remember one of the other elements of a good question, okay, is that you ask one fact, one question. Let's just look at the next slide, because this is your lesson 2. Okay, now Tell me about the car, for example, its make, its colour, and whether there were any passengers. What is the problem with that question? By the way, if you ask this question, you don't break the rules. Okay, but what is wrong with that question? Exactly, too broad, too many questions in one go. What would be, given that we've identified it's too many questions in one go, what is the first question that you should probably ask? If you want to ask all of those things that you can see on the screen, what might you ask first? Exactly. What was the make of the car? Let's imagine the witness says it was a VW California camper van. Okay, that's your answer. And I give you that answer because that's my car, my dearest possession. Okay, so we've now asked, what was the make of the car? All right, the witness tells you it's a VW camper van. What is the next question built into that slide? We've asked the make. What is our next question? What was the colour of the car? Exactly, Joshua. Well done. What was its colour? And let's imagine the witness says, well, it was green and white. It's white at the top and it's green at the bottom. What's your next question? The final question from that scenario. What is the last question? Exactly. Were there any passengers in the car? And then the witness will say yes or no, whatever the facts of the case were. Let's imagine they say, yes, there were. There were 2 passengers in the car. Okay? So they now appear on your slide. What was the colour of the car? What was the make of the car? Were you able to see if there were any passengers? Okay? Between you, okay, Gary, can we just go back one slide, please? Thank you. So between you, you have just conducted a proper examination in chief which corrects everything that is wrong with the question you see on that slide. And again, that is exactly what will be required of you in your first session on the bar course. So well done indeed. So we do have a longer scenario, but I'm very, very conscious of the time. And I know we need to leave some time for questions. And to be honest, you have performed brilliantly across those questions that we have dealt with so far. I hope that you are now very, very clear on what a leading question is, how you ask a non-leading question, and you've demonstrated very clearly that you are able to identify leading and non-leading questions, and also the importance of asking one question at a time and the importance of making sure that those questions are clear and concise. Now, before we move on, does anybody have any questions about those things in particular? No? Okay, so before we go any further, Gary, can I just ask you to flick? There is a slide that begins remember with a smiley face on. Next, 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 next. Yeah, skip. That's it. So remember what I told you right at the very beginning? I can do it. And if I can do it, you can do it. My job is to help you to do it. Okay? So that not only can you do what I do, but one day you may well just do it better. And when you do, you can come back to me in practice and you can say, Miss Emma, please can I deliver an advocacy session for one of your groups, because I think they might just appreciate my skills. Okay, so next slide, please, Gary. time for questions. Now, I'm very happy for you to ask me any questions about the advocacy module, about what we have been through today, or anything else in particular. But before you ask a question, can I just ask you one? Do you feel, and just pop your answers into the chat, do you feel a little bit better about what you are going to face when you come to your first advocacy class? Yes, yes, absolutely. Yes, 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 yes. Hooray! Then I have achieved my objective. So I'm delighted, okay? Because I think it's really important before you join us just to take the edge off those nerves. And if I've achieved that today, then I'm very happy. So are there any questions that I can answer for you? Any questions at all about anything? Anything at all that I could help you with? And I will answer. Can you receive the slides for the presentation? I think so. I don't see any reason why not. Can for me. I'm happy. You to have them.
Emma, there's a question posted by Wasna, and she asked, beside confidence, what do students normally find difficult in an advocacy sessions?
I think what students find most difficult is how exposed you are. So you are, if you feel exposed, that's because to an extent you are. You are on your feet, everybody in the group is watching, and it's very possible that at some point in the year you will make a mistake. Okay? But what we have to do, what you have to do is accept that you will make a mistake. And do you know what? When I'm on my feet, sometimes I make mistakes too. But two things to remember. One is in that tight group of 4 students only, okay, you are in a group where you can make mistakes. Nobody's going to laugh. Nobody's going to point at you. The sky won't fall in, okay? And over time, I will teach you, as the other tutors will, where you make a mistake on your feet, we'll teach you how to correct it. Okay, so if I make a mistake, I ask a question and it's a daft question, okay, I would say to a witness, forgive me, the question that I should have asked you is X, Y, or Z, okay? So I think it's the feeling of being very, very exposed the students worry about most, but you can't get much better than being in a group of 4. And as I've said, everybody in that group is in the same boat. Okay, everybody will be as nervous as you, whether they admit it or not. Okay, so I can see, what is your advice on students on their way to aspiring lawyers? Sorry, I can only see part of the question. Miss, can you see the question?
I think it's not complete sentence. Yeah.
Okay, who are worried about making the wrong decisions. Right, that's a really good question. And that really is one of the big distinctions between undergraduate study and the bar course. When you are on the bar course, you are required to make decisions. You are required to advise the client. And that means you have to pin your colours to the mast. Okay, you can't just say, well, you know, there are cases that say this and there are cases that say that. And sometimes this might happen. You have to say, but in your case, this is my advice. Or when you are on your feet, you have to ask a specific question. Okay, and the vast majority of the time, okay, you will be right. Okay, but developing your confidence in making decisions is something that we teach you to do. Okay, so gradually over the bar course, the scale of the decisions that you are required to make, the complexity of the decisions that you are required to make increase. Okay, so it is a gradual increase, and we will trust you, having done the preparation, to trust yourself. Okay, I think there's a very often students struggle with the idea of, well, why would I know? How can I know? I would never know. I don't know. I don't trust what I think. Okay, over time, you will learn to trust your own judgment, provided, of course, that you've done the preparation. Okay.
First of all, thank you, MT, for the lovely introduction, and also thank you for letting me speak today, especially towards the audience is second year students and also final year LLB students, right?
Yep.
Okay, so I'm currently doing my LLM. I just finished my bar course in May. And if everyone would like to know, Emma was actually my examination in chief examiner. I bet she remembers.
I do. And would you like to tell everybody how you did?
What is that? Sorry?
And how did you do?
Oh, I did well.
Of
And the
course you
results
did.
were
I know
out.
you did. And yes.
Yes. All the BSB results and the advocacy results are out, and I'm quite happy with it.
Yeah, a very smart girl.
Oh, thank you so much, Emma. So just to share in terms of Northumbria Bar School, for those who like to apply, I think it's a very good bar school in terms of what I've the experience that I've learned there. And just to touch into especially advocacy, as Emma has touched into it, what is important of advocacy, I think I would share this part. When I had my first advocacy class, I was nervous. And it's because it's my first experience in terms of I have to learn in terms of examination in chief. So what we have in Northumbria Bar School, where other bar school doesn't have, is in terms of we learn family advocacy. So you have conference in terms of your submission of advocacy. In terms of criminal, you have your examination in chief and also your cross examination. So your first advocacy class would be more like a try and error, because it's where you need to learn from your mistakes. But what Northumbria Bar School also provide, where they have the recording for each of your advocacy session. So my advice to students is that when you join Northumbria Bar School, one of the main important thing is to go through or to review back from the recording that you get in terms of your advocacy classes, because from there you learn from your mistake. That's what Emma has said, that this doesn't require you can have all the experience that you have in hand, but when it comes to advocacy, what's the main thing here is that you need to practice a lot. That's why also she mentioned 90% preparation and 10% performance, which is true. Because I've done the bar course, and I think in terms of advocacy, where what I have is that a week before or preparation before my advocacy class. So you have to practice where in front of the mirror. I know it sounds crazy, but that's what you do. You just stop in front of the mirror, and that's to practice in terms of examination in chief. And when you have your cross examination, and when it comes to family advocacy, where you have to be more friendly. So those practice eventually do help at the end when you come to the assessment, where you become less nervous in terms of also you are able to think on your feet, and the confidence has built up. And also where, like Emma said, you fake it till you make it, which is true, because none of us know what we're doing. I think that confidence is enough to make it seems like you know what you're doing. But also with all the practice and what the tutors, especially Northumbria University, has helped out a lot in terms of giving feedback. And what I like the most for Northumbria Bar School is that when you have any difficulties, or if you want to see your tutor one-on-one, you can just set an appointment, and they will actually sit down with you and tell you that, okay, this is where you need to improve, or in terms of your questioning style. The tutors there, especially, they are there to help you to improve, which is good. And yeah, I really do enjoy my time in Northumbria, and I think it's the best bar school so far. I mean, comparing to all my other friends who are in a different bar school. Yeah. So in terms of the success in the bar program, I think what's important here would be your discipline and consistency. Because from the beginning of the class, where you have especially Northumbria Bar, if you're planning to apply in Northumbria University, where you will start your advocacy somewhere in November. So October itself, where you learn criminal litigation, you have civil litigation, and also ethics and opinion writing. So those are the months that you have to focus on getting your litigation papers revision. You have to start, because once advocacy classes start, then you won't have enough time in terms of doing your own revision. So then I think that's all for me, because time constraint here. answer your question, Wasna, beside practicing by talking the mirror, do you have any advice on how to prepare? Okay, I think first of all, as I've mentioned regarding the recording, when you have your advocacy class, because there's only 4 students inside, so run through your recording first. So whatever you don't understand from the recording, I think another thing, apart from practice, is to ask your tutor, like, where did I went wrong? What did I did? What can I do to improve myself? There's another thing where you have to have self-initiative to be brave, which I understand it's very hard for Malaysian students, especially to come forward to ask questions, which is, yeah, when you're doing the bar course, it's completely different because you need to ask a lot of questions to your tutor to understand a lot of stuff.
Completely right. And I would just add that in terms of your preparation, you just have to be very thorough. I think you'd agree that that's right. That students, you need to read your brief really carefully. You need to analyse your case very slowly and purposefully and understand really what it is that you are trying to achieve. And then, for example, in submissions advocacy, you might write your submission, and it's excellent advice that you practice in the mirror. You must practice with your voice out loud. You must speak it, because a lot of students think that they can prepare by just reading it over, but actually you have no idea what your submission sounds like or what your questions sound like until you say them. And I'm sure you've had this experience where you begin reading out your submission and you think, actually, that is not what I mean, or actually that just doesn't hang together properly. It just doesn't sound right. So always being purposeful and slow really in your initial preparation and careful, and then always speaking it out loud over and over, in the bath, in the mirror, to your friends, on the bus, everywhere. And don't worry, you won't look like you are insane because everybody is doing the same thing.
In terms of the study techniques, I think there's 2 main things here where you have to be consistent. Like I said, the moment your bar school starts, it's not a honeymoon period. It's a period where you have to start doing your own notes. Because like I said, for the BSP papers, in terms of the civil litigation and criminal litigation, it requires a lot of your self-time to do a lot of your own notes, your own understanding, and discipline. But these 2, I tell you, no doubt, I've seen recently I just received my BSP results. I tell you, with these 2 things, consistency and discipline, you can make it through. You can pass the bar program. And even good enough, you can even excel in terms of the BSB papers. Because most of the students who went through with these 2 things, I can see my peers also who has been in the library where I come back, wee hours in the morning studying for the bar course. I've seen also my other classmates who have done it. We all went through. They passed and also excel in terms of the BSB papers. So I think that would be my advice in terms of being consistent in terms of discipline, especially. That's okay.
Do you want to answer?
No, that's okay. I think, yeah, you should answer this part because I think we have the same answer in terms of this.
Yeah. So, yeah, the aim of the game, the main thing is that you achieve the highest grade possible in your undergraduate degree. You need a upper second to access the bar course, and every percentage point counts. So you must obtain that upper second, and it really does matter. And I think when you are a hardworking student, you must, every single night that you choose to work rather than scroll through your phone or watch the TV or talk to your friends pretending that you're talking about something relevant, every single time you make one of those sacrifices in your 3rd year, it matters because you must obtain that upper second class degree if you want to access the bar course. And it's not just the piece of paper that counts, it's the knowledge that you develop in your undergraduate modules that really make a difference. Because when you are on the bar course, you are still using that knowledge of undergraduate law. You will have forgotten a significant amount of it, but you do need contract, you do need tort, you do need to understand criminal law. Okay, so it's all transferable into your bar course. But what I tend to say to students is the content, the modules don't matter so much. What matters is that you get the highest degree classification possible. And if a student is at the stage of choosing which options to take, my advice is always to choose what you enjoy, because you will do better in modules that you enjoy. The number of times I've heard aunties and uncles and mums and dads in Malaysia and elsewhere say, I'd really like my daughter to do intellectual property. And the daughter looks like the most miserable person in the world. And I say, would you like to do intellectual property? And they say, no, I would like to do fashion law. What do you think, Emma? Well, my advice is do fashion law. Do what you are interested in, because you will thrive. Don't do something that appears on the face of it to be quite impressive, but actually is for you is just dull.